Hi, it's Mark Coopersmith, and in my ongoing series of conversations for entrepreneurs, innovators, and corporate entrepreneurs, today I am really pleased to be talking about entrepreneurship, innovation, and the law, and things that innovators and entrepreneurs should be doing, and who they should be working with, and how they should be working when it comes to the legal side of things. Today, I'm joined by two of the top attorneys at Carr and Ferrell, Jeff Capaccio and Brian Bathurst. Gentlemen, thanks for joining me for this Zoom conversation.
Thank you, Mark, for this opportunity.
So we're all here in the San Francisco Bay Area, and nearby are my institution at UC Berkeley, and in particular, nearby Silicon Valley. And that becomes particularly relevant when we talk about the way that many firms, law firms, operate with technology companies, whether it's startups, whether it's high growth companies, or whether it's more mature companies. And of course, there are lots and lots of transactions that take place. It's company formation, it's funding, there's M&A activities, there are stock options to be granted, there are IPOs. It's an environment that is ripe with transactions, and it's also ripe with all sorts of risks. Risks around business law and exposure and liability and intellectual property and deals gone bad and everything else. So one of the key things that I always share with my entrepreneurship colleagues, students, executives is you wouldn't go into battle without a good set of armor. You really should never go into business, launching a company or growing your company without a trusted law firm and a lead counsel by your side. So with that, let's start with, we're gonna break this conversation into two parts, really. The first is, if you haven't worked with counsel before, how do you work with counsel? How do you choose an attorney? If you're a scrappy startup and you don't have a lot of cash, how do you approach it? And then, as you grow and as you have intellectual property that you would want to protect or deals that you need to document, how do we do that? So those are kind of the two chapters of our conversation today. Jeff is probably going to take the lead in chapter 1 with comments from Brian, and Brian the lead in chapter 2 with input from Jeff. So Jeff, let me start with you. Let's say we've got some early stage entrepreneurs that haven't done a lot of work with legal counsel before, that have an idea, that have a couple of teammates, they're getting ready to go out to market, or they are thinking about starting to sell their product. First question, and then we'll talk about counsel, is when should they actually create a legal entity?
I would say very early on in the process to start getting things in order, to make sure that ownership is clear, duties are clear, because when everybody's friends and really enthusiastic about a project, it's really easy to all get along. You want to avoid situations downstream where you're starting to have some disputes, or maybe somebody has fallen out of the mix, and so you want to have everything clean from the very outset, to have everything very well documented. Who owns what, who does what, who contributes what, that kind of thing.
Right. Well, one of the other things too that for me is always important is when you bring people together, each of us brings something different to the party, right? Brings something different to the organization. The importance of an entity, at least from my perspective, and then to you, is if I bring intellectual property, let's say it's some technology, or let's say it's customer relationships, do I as an individual own those, or does our company own those? How does that work?
Well, it depends, I guess, how you set it up. Optimally, you will want the entity to own it, so it's nice and clean. Again, especially everybody gets along in the beginning and maybe not at the end, so you want to make sure that's clean and there's no issues.
Yeah, so let me break in quickly. So that means, let's say I'm the technology head. If I come in, I've got an idea for a company, or you have an idea for a company, but I write the code to launch a product, and then you and I have an argument and I leave, do I get to take my technology with me, or does it stay with the company?
Well, if it's not has been assigned to the company and the company can't legally claim any ownership, it's the individual.
Yeah, so this is one of the reasons why, as entrepreneurs, you always want to make sure that the company owns the intellectual property. Because let's fast forward that case study. Let's say that Jeff comes up with an idea. I join. We raise some capital. There's 30 employees. There's a bunch of customers, and I get tired and decide to leave. Can I cripple the entire company? We don't want that to happen. So we want to make sure one of those key agreements is the prior inventions or the assignment clauses
Correct.
of that. Share with us a little bit how that works, Jeff.
Well, the idea is, again, it's all about documentation and making sure everything is understood at the outset and everybody knows the rules under which they're operating. And in this case, if anybody that's contributing, inventing, what have you, you're making sure that that gets assigned to the entity.
Right,
so
right.
There's no dispute later on.
So we're going to come back to this, Brian, in just a little bit when it comes to intellectual property and kind of how you protect it, but anything in particular with how you might ensure that that gets assigned properly? What elements, for example, might get assigned to the company?
Anything pertaining to the technology of the company. And that can be through the employment agreement. It can be also through after the employment agreement, of course, and you want them to assign anything that they come up with during the course of their employment. Also, you want them, with respect to patents, to sign separate patent assignments that are recorded at the USPTO. And another concern that comes up from time to time is this new person coming to your organization. Are they bringing baggage, i.e. IP, from their former employer? Because you don't
Right.
want that to happen either.
Yeah, you got to be really careful that there's not risk associated with that. If you're building a product on somebody else's technology, you've got a real problem, don't you?
You do.
Yeah, let's call in the litigators at that point. And you raised something interesting. In fact, I'm going to grab it right here. Do I have it? I do. For those of us, so here's a patent that I'm on for one of the companies that I'm a key principal in, or was. We sold that company, but I assigned all of that intellectual property over to the company so that the company could commercialize it. What I have left on that is my name on the patent and this lovely little lucite that shows that I actually have a patent. So despite that, there was value created as a result of this patent that went to the company. And of course, we were able to use that value to generate revenues and eventually sell the company to a multinational. All right.
May I interject? To this day too, that company that owns that patent wants you to be very happy, because if they litigate that patent today, they are going to want to depose the inventors.
Yeah, right.
And you're not going to be too good if you really got an axe to grind with them.
Exactly. That's exactly right. Exactly. So let's come back to kind of how you choose an attorney. So there's a few of us sitting around. By the way, one of the other things we have to be careful about is when we start getting revenues, if we have a customer that is ready to sign up and we don't have an entity, who does the customer create an agreement with? Where do the revenues go? Who pays the taxes on those? All of those things. So when it comes to whether it's creating intellectual property together, going to market, generating revenues, raising funds, you always want to make sure you have your entity in place before those key milestones happen. Otherwise, it gets pretty complicated. Just to have a few conversations with your buddies and maybe go do some early exploration, too early for an entity. But once you start moving forward, as Jeff said, that's what you want. So now, Jeff.
And the expense is relatively minor. I mean, a corporation or a limited liability company is not a huge expenditure. I mean, it's
so what does it cost?
A few $1,000s, $2,000, $3,000 for a basic vanilla corporation, and with the usual basic documents, articles of incorporation, bylaws, organizational minutes, resolutions, etc. And then the project gets a little bit bigger after that, but at least to get you started initially out of the box, it's not a huge expenditure. I mean, you should be able to scrape that together.
I remember the very first time that I put a company together, I was surprised by how thick the binder was, but most of that's boilerplate. And certainly if you're building a company that is going to be out looking for funding, there's some pretty standard forms. There are times when an LLC might make a lot of sense if it's a professional practice, but for most of our Silicon Valley type technology startups, there's really one corporate form that you want, right, Jeff? What would that be?
That's correct. It's a traditional corporation, a C Corp, and it'll either be a California entity or a Delaware entity typically. And a lot of this is also determined by who your investors are. And the investors may dictate that they want a Delaware entity as the entity.
That's been my experience, by the way. There have been one or two co-founders that said, I want a California corporation. My investors have said, no, Delaware. Because Delaware is kind of set up for that. Their website is great. If you need something at 3 a.m. for your board meeting the next day, you can go online and Delaware has it ready for you. So that's been my experience anyway. I know there may be other reasons to stick inside the state of California for that. Now, how do you go ahead and pick a good counsel or a different firm? Pick a law firm, pick your counsel. What would you suggest people look for?
I mean, a lot of it is talk to other entrepreneurs, talk to other folks, say in this sort of Silicon Valley, Northern California ecosystem, and see who they've used, ask around, see what their experience is working with startups or intellectual property, and it's not that hard. We kind of know who everybody is that operates in this space.
But
and
Jeff,
there's a lot.
Jeff, my Uncle Frank he's in the family, right? Yeah, he mostly does divorce law, but still, he's an attorney. I think I should just go ahead and use him, shouldn't I? Brian, what do you think? You're smiling.
I don't know anything, thank God, about divorce law. And, though we get a smattering of everything in law school, you have to practice it for a period of time before you have any expertise.
Yeah. So you mean Uncle Frank should not be on the top of my list, even if he gives me the family discount?
Yeah, or your cousin Vinny.
Yeah, exactly. So one of the key things to think about is both Jeff and Brian said is as you're choosing counsel, find somebody who is deep in these areas of expertise. You don't want your family counsel, you don't want your probate lawyer to be setting up your high growth company because they're not going to understand the way things are done today, September 16, 2020, and what the standard terms and conditions might be today versus what they were even 3 or 6 months ago, because there's a lot of things where the standard elements do shift over time. And there are a couple of firms that often will help drive that, whether it's law firms or key accelerators like Y Combinator or things like that. Okay, so ask around. What kind of first conversation should you have? And should I pay for my first conversation with an attorney?
Typically not. Typically, it's at least our firm's policy to not charge for an initial consultation. I mean, that's a get to know you and see if we're comfortable working with each other. And I think that's really important. And you should ask questions about how billing is handled and if they have any alternative arrangements. And if
what do you mean by alternative arrangements?
Say on a project-based billing or flat fees in addition to hourly rate. I mean, typically a lot of the initial corporate work is pretty much a range or flat fee because it's fairly predictable from our end what that's going to involve.
Right.
And so you should be asking all these questions and make sure that it works with your budget and works with what your prospects are for a financing or whatever. So
one of the things that I often think about is the division of labor with kind of all of the partners that I bring around me as an entrepreneur, as a business executive. What should I, let's say as the CEO of a startup or a growth stage company, be thinking about and doing? And what should I ask my attorneys to think about and do? For me, I always say, look, I should be focused on the business issues, and my attorney should be focused on identifying areas of risk and figuring out how to navigate those elements, whether it's contracts or intellectual property or employment law or those areas. How do you have that conversation with clients, especially those who may not be as experienced in working with law firms and outside counsel? What advice do you give them?
Well, I think it's important to have a good open dialogue and ease of communication between both the entity and its officers, managers, et cetera, and the law firm. And I'm here to also invest in my clients. I want to make sure they're successful. So I also want to make sure that they're telling me about issues or telling me about problems early on when it doesn't take much effort to fix them.
Yeah.
As opposed to, hey, by the way, I just entered into this agreement with such and such company. Can you look at the agreement, see if I've made any mistakes? I mean, that's something that would send chills down our spine as
You mean
as
after
attorneys.
the ink, after the ink
After
is
the
on
fact?
contract?
Yeah, exactly.
Yeah.
Exactly.
Yeah. So let me break in. I think that's a really important thing. One of the things that I always advise is just keep your counsel up to date, and you can have that conversation with counsel as well. I mean, Jeff mentioned on things like, billing arrangements. If it's a 3-minute phone call just to say, look, I just wanted to keep you in the loop, Jeff might say, no, that's okay. Just keep me in the loop. Don't worry about me charging for that 3-minute phone call. Now, Jeff might say, no, I want to charge for that. But more to the point, just providing those updates on a regular basis. So your counsel may actually see something lurking in the shadows that you completely miss as something that could be a huge issue.
Yeah, I'm not going to sit there and worry about 6 minutes or 12-minute increments on billing. I do want my clients to keep me up to date because that may necessitate some further work or further intervention later. But just keeping me periodically apprised, either by phone call or just shooting me a quick email.
Right.
And
Well, I mean, and there's the elements of kind of the ongoing work that we're talking about, and then there are the big chunks of work, both for law firms and also companies, a funding round, a merger, a major agreement with a partner. I mean, those are a public offering, of course. Those are things where from both sides, there's the expectation of a lot of work. And yeah, of course, there'll be fees attached to that, but there's typically financial value that's being created at the same time.
correct. But we very much view it as a relationship too. It's not just a transactional arrangement, but it's also a relationship. Again, I invest in my clients. Brian does the same thing. We want our clients to succeed and do well. We want to create the next unicorn or similar.
Right. Unicorn, decacorn, whatever they are now.
Right.
So, all right. Last couple of thoughts, and then we're going to turn to intellectual property. So I've retained your firm. I've retained you and Carr and Ferrell to help me incorporate and kind of set me up, make me legitimate. What happens? What do I get? I get my binder with what? What are the forms that I want to get? Kind of what's that starting package look like that you really want as an entrepreneur?
I mean, it can range depending on the complexity and what's involved. Are we talking stock options? Incentive plans, kind of things at the outset. I mean, typically when we're forming an entity, it's the articles of incorporation, bylaws, organizational minutes, resolutions, invention assignment agreements, all the kinds of little pieces to make sure that every step is documented and that you've followed every step.
Right.
So, your investor representation letters to, make sure you're the appropriate kind of investor in the company, that kind of thing.
Yeah. So there are just a lot of forms that you find yourself using every day. Things like an offer letter.
Correct.
An offer letter should have a particular form because it holds legal weight. The inventions assignment and confidentiality, which you mentioned, really important because in a funding round next year, the venture capitalist or whomever, or if it's an M&A activity, might say, show me that every employee has assigned all of their intellectual property that you represent, you own, to you. And if you don't have that, that can blow up an entire transaction if it's a key piece of IP, right?
Yeah, and again, it's coming back to what I said earlier. It's all about documentation and making sure every I is dotted, every T is crossed, that everything is clean. Because when somebody is going to invest in you, they're going to want to make sure that everything has been properly scrubbed, because cleaning it up later is messier, especially when maybe not everybody's on the same page or getting along. So
Yeah,
you want
you
to make sure
want
that's handled at the very outset.
that's exactly right. You want to make sure that you've got that covered properly at the right time. You don't want to get out there too early. You don't want to
Correct.
spend money before you need to. But when you think you've got a real entity that's starting to take shape and you're going to be doing some commercial transactions, it's worth it. And it's not that much money. Now, let's move on from this to something that can start to cost a reasonable amount of money if you've got a reasonable amount of technology or other specific brands, intellectual property that you need to protect. And Brian, we're going to turn to you. And this entire concept of intellectual property protection. And if we were to talk about it at its highest level, when somebody says, what is it you do? How do you work with business owners, et cetera? What is that?
I'm a monopoly architect, and I know monopolies in general are not a good thing, but with
No, we
intellectual,
like monopolies, actually, if we can make them happen as entrepreneurs, right?
exactly. And our clients can't afford, well, some of them, we do have some that can, but for a startup, they can't afford to patent everything that is new and non-obvious. They need a plan. And I think what sets us apart from other firms is we have a strategic intellectual property program that we counsel our clients, and we develop a strategic intellectual property plan. And this is a graphical layout of the IP assets that they have and that they intend to get. And they can share this with investors and say, hey, we have a plan, we're going to build value. And this starts with a business question. And that is, why does the end user want your product or service? And if you can come up with that answer, then question number 2 is, what are the technologies that enable it? And those are the technologies that we patent. And we build those technologies around those reasons so that if anyone tries to get to that reason in terms of a competitor, they're going to infringe one or more patents.
Right. All right. So you focused on patents, and we're going to spend a lot of time there, but we'll also talk about some other elements. You also used kind of in the course of that description, some terminology that actually has legal meaning. When you talked about, for example, non-obvious, new and non-obvious, there are elements there that are really important to distinguish between something that's patentable and something that might be protectable in other ways. Is that right?
Correct. There's also trade secret protection. That is your list of vendors and your recipes and that sort of thing that may not be patentable, that you protect through trade secrets. Couple differences.
Well, and there's actually a challenge when it comes to trade secrets. Perhaps the most famous or off-coded trade secret, right, is the recipe for Coca-Cola.
Correct.
Supposedly half of it each in 2 different safes and a total trade secret. But
And I'm sorry to interrupt, but the law does encourage reverse engineering of trade secrets. I'm free to reverse engineer anything I want.
right. And one of the challenges of a patent is you have to disclose. So there may be certain intellectual property that might be patentable, but you might choose not to patent it for exactly that reason, because you don't want to actually disclose and provide someone that pathway to reverse engineering, correct?
Correct. The big difference is patent infringement is strict liability. And that is, I may not know you, but if I'm infringing your patent, I'm liable. A complete defense to trade secret misappropriation is that, hey, I never met you. I did not have access. As the plaintiff, I need to show that you had access and you misappropriated it. And so, that is a big difference. And, there are formalities that you have to follow. Now, I will tie the 2 together through what we also do. And that is, we provide our clients with invention disclosure forms. You want to encourage your employees, when they're solving a problem, to write down that solution, turn it in to management, just a couple of pages. Management can look at it and do 1 of 2 things. They can say, yeah, let's send it over to the patent counsel and we can pursue it as a patent, or they can protect it as a trade secret. Because if your employee gets cherry picked to your competitor and they go over and they quote invent it there, it's trade secret misappropriation.
Right.
So
Right.
the two do dovetail.
Well, one of the other things, and when I have visitors that come and we visit some of the top firms in Silicon Valley, they'll note that the security procedures are pretty strict, as they are in many companies. But in particular, there's forms that you sign, there's photos that are taken, there's access that's limited. And part of that, speaking with counsel inside those companies, is to help ensure not just that people that shouldn't be there aren't there, of course, keep the bad guys out, but also, as you were talking about, to document that you're taking appropriate steps to protect your intellectual property, that you know who was there, so that you have those proof points just in case any of those issues do end up being disputed. So it's really interesting. People don't understand that that the legal issues are part of why the security is so tough.
And one thing I say over and over again, and that is you want to be sure you file on your invention before you publicly disclose it or offer it for sale. And I've had clients that have gone to big companies that we've all heard of and share the idea with them and then run to the patent office. And they find out that big company beat them to it.
Right.
And we are now a first to file system, not a first to invent system. So, I can't emphasize that more than to first file. Also, try to be proactive. You can file prophetic examples in your applications. So let's pretend I am the chocolate company and I'm going to meet with the peanut butter company. You know what? I could file on the Reese's peanut butter cup before I meet with them. So we're not someday saying, oh, I came up with this part, or I came up with it first. Hey, I filed on it first. If it's something that you can, because you've got to have a reason for talking to someone else, and come up with some prophetic examples and file on it.
Right. So try and envision the future. Now, patents are renowned for being expensive to file and expensive to prosecute or defend. But there's a first step that you can take when you say, get out there early. What's that first step before you actually file a formal patent filing?
Well, something that is quick, simpler, less expensive is to file a provisional patent application and get the filing date.
And what does the provisional patent application do?
What that does is it gets you the benefit of a filing date so that prior art begins on that date and behind that date. Whereas it's putting your stake out there and establishing a date. And that's very important. You can show that you're first to file. And then when you filed a more formal non-provisional patent application, you can tie back to that date.
Right. So for me, having filed patents before, right, as I shared earlier, the provisional was always a place where you throw really almost, not entirely, but almost as much future vision that might be applied to this patent, right, the chocolate and the peanut butter, if you will, components into that provisional, and then your formal patent filing focuses on those elements that you've deemed most essential or necessary to protect. At least that was my understanding. I'm sure you can provide some nuance around that.
Correct. I actually have a client who filed 2 provisionals about 800 pages in length.
Wow.
Each of them. I wouldn't recommend that. You're going to pay extra page fees to the patent office. The nice thing about that, though, is they did cover everything they could think of. And, and of course, as you pointed out, in the non-provisional, you're focusing in more on, a specific invention as you see it. And, keep in mind, too, the patent gives you the right to exclude others, not the right to do something. But getting back to an 800-page provisional, there's been a time or two where the examiner says, where's your support? And it happens to be in the provisional. And you can go and borrow from that provisional and put it into your non-provisional. It's kind of like a large tool chest that, if you need something, you can borrow from it. And sometimes that comes in handy.
Well, from a practical standpoint, the provisional does several things. One, it puts a stake in the ground, so it gives you a priority date. Two, it gives you time to go out and fundraise and have discussions with people with some sort of peace of mind. And three, it's relatively inexpensive and quick. So, I mean, it offers a lot of advantages.
Also, and you probably know this better than I do, but most VCs are not going to sign an NDA, when you have your conversation with them. And you're a lot safer having that provisional on file before you start discussions.
Yeah, way back when I first started, you'd be able to get NDAs signed. Right now, it's pretty hard to get those non-disclosure agreements signed, especially on the first or second or third meeting, maybe in the 10th meeting by the time you're really getting into the core technology. But it's a tough one. You're absolutely right.
Well, and then again, an NDA is not going to protect you from everything too, right, Brian?
No, it's not.
Correct.
That's exactly right. That's exactly right. It may provide some recourse, but even that's difficult and you have to pursue it. So we've been talking about patents, and patents can cost a lot of money. But by the way, is there such a thing as an average patent all the way through granting, kind of what the average cost might be?
I know the American Intellectual Property Law Association puts out a report of average costs throughout the country. I can't quote you that book verbatim, but there are a number of ways that we can do it to accommodate a client's budget. And, again, the provisional patent is a good way to start to see if you're going to get traction, as Jeff mentioned. And they run, I don't know, typically $3,800 plus filing fees upwards. And it is a great, if your technology is not worth investing that amount, maybe you shouldn't be pursuing it.
Well, one of the other things, so for me, my experience has been kind of 15,000 to 35,000 plus or minus is kind of a typical range for a patent, but it can go up to six figures depending upon complexity and who else is playing in that field. Just from a broad range, does that feel at least ballpark?
100K is a lot of money. And let me back up a bit and mention, we try to do our filings for a flat fee. So there's no fear when the client picks up the phone to call me that, I'm turning on the meter. We all know at the start what it's going to cost. And it's a real nice relationship. I really like flat fee services when possible. Back to your other question, when you file the non-provisional and you get into prosecution, yes, it is very easy to go up to 100K, but there are also great ways to avoid it. I think the thing that I do that I really like doing is establishing a conversation with the examiner. Instead of throwing paperwork back and forth, after that first office action, sometimes even before it, get on the phone and, just have a frank conversation as to say to the examiner, after you go over your points and, and your points might work and end of story and you get an allowance, but if it's not working, say, hey, I welcome your recommendations. Do you have any recommendations?
Right.
And a lot of times they're happy to provide them. And a lot of times that gets to an allowance because they also share a benefit in getting that application off of their docket.
Right.
They're given very limited time to look at applications. And also discussion can educate them a lot more quickly than them reading through your application. And, I'll admit, as a patent practitioner, sometimes those applications can get pretty esoteric.
Yeah.
And it's a great way. And also, you can say a lot of things that won't go on the record. They can say a lot of things they won't put into an office action. Typically, the interview summary will be a paragraph.
Got it.
At tops. And
So
a paragraph can't capture a 30-minute conversation in full.
So one of the things that's important to think about, and most patent attorneys would have some of those same experiences that you do, with somebody that has good relationships with examiners in particular areas, right?
Correct. I've worked with a number of examiners, numerous times to the point we're on a first name basis.
Yeah. One of the interesting things about many patent attorneys also is that they have technical expertise in addition to legal expertise. So you'll find many patent attorneys that have engineering degrees or medical degrees or other elements so that they really understand the core technology that's underneath that. And that differs from other types of intellectual property like trademarks and copyrights and things like that. So when we take a look at the spectrum of intellectual property protection, we focused on patents as a way to particularly protect core technology. But can you just spend, as we get ready to wrap things up, can you spend just a couple of minutes on some of these other areas, trademarks and copyrights? We touched on trade secrets earlier.
In my earlier days, I filed a lot of trademark applications with, again, the United States Patent Trademark Office, though there is such a thing as state trademark protection as well. But in general, I support the federal system. A trademark identifies you as a source or origin of goods. And the best trademarks are words that have no meaning in the English language. As far as I know, Nike does not have or didn't have a meaning in the English language. And those are the best trademarks. The downside is you're going to spend a lot of money to establish what it means in the mind of the consumer.
Yeah, so we're talking about many of those drug companies and their new drugs, right? Which are manufactured names.
Definitely manufactured names. And then they try to associate. When I was watching football, I think it was Sky Rizzi this weekend, and they show a Skyrider up in the sky,
right,
so you'll remember it. And they have to make those sort of investments. But a trademark is very, very valuable. And of course, a couple things that go along with getting it. Number one, you have to defend it if it's being infringed. With the patent, you don't have to go to defend it if someone's infringing it. But the trademark, you most certainly do. And like I say, the worst trademark would be a descriptive mark, like bottle of water.
Yeah.
I don't think you're going to be able to get much protection for that.
Well, and if you're launching your business that has, for example, your own name, like Coopersmith Pens, I have more capability to protect that with my name than I would just pens, correct?
Correct, exactly.
Yeah. So, yeah, so that's one thing. All right. So, and do you have different categories as well within some of these intellectual property protections? You can register for all categories or for specific categories. How does that work?
With regard
classes,
with trademarks, there are a number of categories because trademark infringement is basically a two-pronged test: the closeness of the names and the closeness of the goods or services. And when you register your mark and you pick a service or product that you're associating with, you're going to have to show them proof that you're actually doing it with that particular product or service. You just can't pick all of it and not work in those areas.
Right, right. So I remember this was many years ago. I was working in the entertainment business and the electronics business in my days with Sony, and Apple, which was the music label for the Beatles, was getting ready to contest Apple, the computer company. And the computer company, Apple, said, there's no way we're ever going to be in the entertainment business. We're a computer company. So Apple Computers got the rights for certain categories and Apple Core or Apple Music for other categories. And well, we know what's happened since then. So telling the future is a difficult thing to do. And we need a little help sometimes to navigate that.
So true. And to touch upon a related area, there's also trade dress. Now that is if you come up with a chain of restaurants with golden arches, and I'm not sure if they still use the golden arch, but certain colors and themes, and the workers wear certain outfits, you can get trade dress protection for that.
So you have protections, and that's right. I mean, it can be certain colors or certain types of shapes, right?
Right.
So that's all part, yeah. And then what about copyright?
Copyright, that goes to the original expression. does not go to the functionality. So say I wrote computer code and I have 1 + 4 = 5. Okay, someone else is free to come along with 2 + 3 = 5. It's the original expression,
Right.
and that you find in books, floor plans, music. I had a client that was a home builder, and he had numerous home plans that he would share with customers. And there was a contractor about an hour or two outside of town that was using the same floor plans. And we wound up suing him for copyright infringement. And then in meeting with that particular defendant, asked, why are you doing this? And he goes, well, your client's plans are so well accepted, I just thought I would do the same thing.
Right. There you are. But you can't always pay that highest form of compliment, as is sometimes said, right? So, yeah. And I'm trying to remember what the other expression goes, something like copying from one person is considered plagiarism, but copying from many is considered research. Now, I'm not sure about the legal interpretation of that, but those of us who are looking for new innovations might take note.
True.
Yeah. Brian, Jeff, thank you so much for sharing some insights around how to engage with a legal firm, how to protect your intellectual property, how to think about the different categories of intellectual property. In fact, building on our final conversation right now, this video is copyrighted by Brian, Jeff, and Mark 2020. And we can actually claim that, can't we?
We can.
We just did. That's the unique expression, and we did it first. With
And
that,
Major League Baseball has nothing to do with it.
I'm sorry?
I said Major League Baseball has nothing to do
Yes,
with
that's exactly. With that, I'll also include some information about Carr and Ferrell in the description to this this video on YouTube. So if anybody wants to reach either of you, that information will be there as well. With much appreciation, gentlemen. Have a good day.
it.
Thank you.
Thank you.